Commissioner's office has jurisdiction over the public sector in the Berlin state administration and jurisdiction over all companies with their headquarters in Berlin. We are applying state law to the public authorities of Berlin, and we are applying one uniform federal law to the private sector, as do our colleagues in the 16 German states. And the Federal Commissioner has jurisdiction over the public authorities on the federal level, the federal government, and the telecom sector, which is a special sector. We're taking up citizens' complaints, following up on them, asking questions and probing the data protection, data processing procedures taking place in Berlin. We have a right of access and a right to get answers to our questions from all public authorities and private companies. And if they refuse to do so, in the case of private companies, we can even impose fines. We have, for instance, jurisdiction over the largest employer in Germany, which is the German Railways, which has their headquarters in Berlin. And besides that, we are giving advice to Parliament when bills are introduced with repercussions on data protection and or freedom of information. And we also audit authorities and private companies without any complaint, because we think this is an important procedure and there's a public interest to have this audited at our own initiative. So we don't need complaints to become active. And these are our three main areas of activity. Commissioners are very different in the public sector and the private sector. In the public sector, we can only, and this is similar throughout Germany, we can only state in case a breach of the law has occurred. We have no sanctions against public authorities. We can tell them you've broken the law, and we can make that breach public and bring it even before Parliament to ask the government to answer questions of members of Parliament in this respect. But we have no formal sanctioning power against public authorities. Whereas in the private sector, we can impose sanctions and financial sanctions. We can even, to a certain extent, initiate criminal proceedings. We can call upon the public prosecutors to get in. And as far as financial sanctions are concerned, we have, for instance, imposed a rather high sanction on the German Railways in 2009, over 1.1 million euros, which they actually paid because they were spying systematically on their employees. And this was the highest fine imposed by one German data protection authority in the history of data protection legislation. And it was successful in the sense that the German Railways actually changed the whole structure, the internal structure, and gave much more importance to data protection since this has happened. So it was not only a substantial fine, but it also led to a change in internal management. With regards to the public sector, one can argue that the powers to state that a breach of the law has occurred is insufficient. Currently in Europe, a new data protection framework, legal framework, is under discussion, and there it might be that the European legislator will provide for sanctions even against public authorities. That is very much under discussion right now in the European Parliament, but the new European data protection regulation will also provide for higher sanctions against private companies, higher than provided for under the current German law. So our stick or our sanctions will get more effective once this European legislation has been adopted. This has its own budget and this is part of our independent status. We have, in fact, we are completely independent according to the jurisprudence of the European Court of Justice. All data protection authorities have to be independent, and this implies that we can apply for additional funds, and no government can actually criticize or modify our appeal to Parliament for more funds. So we are directly defending our financial needs before Parliament, and in the past year, or in the current year, our budget amounts to, all in all, around about 3 million euros. From that is 2.6 million for staff salaries, and the rest is computers and other things we need. But the bulk part of this budget is obviously personnel and salaries. Structured in, it has 4 departments, 1 central department, 2 legal departments and 1 technical department. All in all, I think lawyers and technicians, informatics experts are cooperating in our office very closely. This structure has been developed for historical reasons over the years, but it is certainly the case that the importance of technology is increasing all the time, but legal questions still raise a number of difficult issues, and therefore this structure has proved to be most effective. And we have, of course, 4 key executives leading these 4 departments, and then the Commissioner leading the authority as such. I would certainly advise or suggest that India should give the future of the Commission a strong independent status. This has proved essential in the European context, and certainly Germany had to revise their legislation due to a case brought by the European Commission. Some of their authorities were not fully independent, so this independence is so important because no government authority should be able to tell the Privacy Commissioner what to do. Since the Privacy Commissioner will have only limited powers, it is on the other side essential that the government cannot direct him or restrict his action in any way, otherwise he cannot carry out his duties properly. So full independence is a key question. What has proved very, very useful and very, very good solution to the conclusion as this in Berlin. Our office has the same status as family departments, so it's on the same level to be on equal footing once there are problems, and I have discussed with the minister, a member of government, in order to convince him or her that something needs to be done. If the Privacy Commission will be of a lower status or below the status of members of the government, and will be a problem, we will not be taken seriously. So there's another thing that is really important, is I would further suggest that the Privacy Commissioner is elected by Parliament, and is probably under the certain supervision in terms of personal listing of the Speaker of Parliament. No, that's certainly not the Prime Minister or any member of government, so he should be elected by Parliament, which again strengthens and underlines his importance. Being elected by the Berlin State Parliament twice, and this is a very good position I aim to underline the importance of this office. I think any privacy commissioner is facing at the moment is the vast and fast development of technology. Thinking of the internet issues such as wearable computing, if you think of Google Glass or cloud computing, technology is evolving so fast that it is very difficult to think of and find preventative solutions and protect the citizens' rights in face of a development which is accelerating even every day. And to defend individual autonomy in face of such a development is our key task, and it is on the one hand difficult, but on the other hand we sense that there is a great consciousness in the German public, at least, of privacy problems, and with this support I think we can carry out our task, but we need the support of the public as well as parliamentary support, for instance vis-à-vis government actions, public authorities actions, including, for instance, activities by intelligence services. So there are sensitive areas concerned, but these are certainly not easy tasks, but we have during the past 30 years solved a lot of problems, but the challenges do not decrease. On the contrary, they get more and more, and we have to keep up with that. Difficult to single out one specific type of privacy violation. I would say that in only very few cases there is outright not many public authorities intentionally violate privacy, or companies. Very often it is the outcome of negligence, or business models are drafted in such a way and are thought out in such a way that no one takes into account that the customer and the employee has certain privacy rights, which should be taken account of from the start in kind of privacy by default setting. This is our main problem, to get into to talk to developers, manufacturers and designers of processing of personal data, be it in the public or in the private sector. The private sector is getting more and more important. Public sector mainly buys products such as software or hardware on the market, but it's more and more important to get into to instill into the brains of developers how important privacy protection from the start is, without excluding the individual's choice. But someone should not be offered a privacy violating product or software which is difficult to modify or configure afterwards in a privacy friendly way. Very often it's not possible at all, so it is key what is the starting point and the default position. There's some differences in terms of resources and staff, numbers of staff, and sometimes also the position, the status, the constitutional status in the legal framework. For instance, not all European data protection commissions have their own budget, which they can defend before Parliament. But in basic terms, we all share a common structure and common tasks, with some slight differences in other countries. Basically, I would say we already have a rather harmonized situation. Where there are differences, this concerns really the resources. There are offices, even in Germany, which are less well equipped as our office, and there are even some offices which are better equipped. So there is not a complete equal situation throughout Germany or even throughout Europe. There are also some small European member states which are less well equipped than our state office, so one has to acknowledge that. India could, of course, has its own culture and traditions, but it would certainly be useful to look at the European example. There are other examples, for instance, the Asian Pacific framework, which is developing. But Europe has a strong and a high standard of data protection, and in order to entertain trade relations with Europe and to have a safe and secure legal framework, for instance, for lots of outsourcing, which is going on already now between Europe and India, it would be a good idea, I think, to look at the European standard, because that still is probably the highest standard in the world. If India would follow this example, it would not have any difficulties in adapting its internal legislation afterwards. So I would advise to look at several models. There are OECD principles on privacy protection also, which are rather general, which are at the moment being redrafted. There is the Council of Europe Convention 108, but the framework within the European Union is probably the best to look at, and although it's under review itself right now, the directive of 1995 and the recent proposals by the European Commission could be a good basis for legislation in India. This discussion on co-regulation or self-regulation in Europe as well, I think mere self-regulation, exclusive reliance on self-regulation would be insufficient. That is something also proposed in the US context, whereas in Europe we support the idea of self-regulation, but only in an existing legal framework. First of all, you need a legal framework. You can then say additional clarifications or maybe even better privacy protection could be foreseen by parts of industry, industrial associations for their part of branch of the economy. That can be very useful, but it could not be done, I think, replacing legislation or regulation. So in that sense, I'm very much in favor of co-regulation. It has to fit together, and exclusive self-regulation will not solve the problem, since after all one should not leave this question to market forces. We need some minimum standard set by Parliament, by legislature, and then enforced by the regulator, and additional provisions maybe in a degree of detail which Parliament could never achieve, could be done by way of self-regulation, but it has to be a combination between both elements. This question needs at least two answers in a very simplified manner. We need a political and legal solution to these problems. We need an international agreement where privacy, especially in the modern cyberspace era, is protected by an international agreement. We have a human right on privacy protection already on the UN level, but this should be enlarged and specified. So this will take a considerable time, because governments usually for these international conventions take a long time to negotiate them. Therefore, on the second level, we need now technical methods to protect citizens' data. One solution could be to use and to develop easy-to-use tools to ensure safe and secure communication, such as encryption. Regulators and parliaments could even think of, and this is a proposal being discussed in Germany right now, to oblige telecommunications providers to encrypt their communications they transport by default. This is not the case at the moment. This would at least prevent intelligence service, foreign intelligence services especially, to get into the communication, in the data flow, and monitor and tap into the data stream without any possibility to control and prevent that. So encryption is a very important tool, and other technical methods should be discussed as well. And it could be also that, at least in Europe, we are now discussing, for instance, in the context of cloud computing, that only European cloud providers should be used by European controllers, because only under European law is there a minimum amount of control in case of access of law enforcement agencies. Obviously, there are situations where law enforcement agencies have to get access to these data, but there have to be rigid controls and much more effective controls as there is in place at the moment. This applies to to the NSA, the US intelligence service, as indeed also the UK GCHQ. So it's not only a US problem, it's a global problem, and therefore it should be tackled and discussed at least on these two levels.